Good evening and welcome to the Startup Launchpad and our seminar for this evening. My name is Brad Barbal. I am the Executive Director of the CSUMB Institute for Innovation and Economic Development. We are the hosts of the Startup Launchpad Incubator, and we are very pleased to have with us this evening Patrick Reilly to speak about intellectual property, which is a key issue for many startups. Before we begin, I'm going to welcome everybody and a couple things. In case you missed it, we're on Zoom, and that has a few implications. First of all, it will help if everybody can keep yourself muted so that we don't have background noises to deal with. If you want to speak, you are able to speak, but you'll have to unmute yourself. We are recording tonight's session. We will be posting this session on the Startup Launchpad website and on the Startup Challenge website. So if you don't want to be heard or seen, you should keep your camera off and stay muted. If you have questions, we do want questions. Patrick is looking for questions. So best way is probably to put those into chat and I will relay those on to Patrick. And with that, I'm going to introduce tonight's speaker and turn this over to him. Tonight we have Patrick Reilly, who is a lawyer in Santa Cruz. Patrick has worked with, I don't know if he knows how many, but it's certainly in the hundreds of startup companies and other companies around intellectual property protection. And all of us who are starting companies need to be versed in how we track and manage and protect our intellectual property. And he will be speaking on that tonight with his talk entitled Intellectual Property Issues at Venture Birth. And with that, I'm going to turn this over to Patrick. Patrick, you ready to go?
Yes, Brad, thank you for that generous introduction.
It's all yours.
All righty. With Zoom presentations, I'm reminded of what IFR rating means in flying civilian aircraft. IFR stands for I follow roads. Unfortunately, I can't really see anyone. So I'm just looking at my slides, and I encourage you to send in chat messages that Brad will interject. And we'll get your messages into the heart of the presentation, which is what I really prefer to do. I prefer this to be as conversational as possible. So my first slide is, why are there IP rights? And Brad, can you confirm that you're seeing my slide properly? I just want a little reassurance there.
I am.
Okay. All right. So why do we have IP rights? Well, the purpose of intellectual property rights is specified in the body of the Constitution, which is quite odd, or special, I should say, special, because it's the only civil right explicitly mentioned in the Constitution as opposed to the Bill of Rights, to the amendments. And the purpose of the right is specified. It's not just, you know, it's obvious on the face of it that people are supposed to have these rights. There's a purpose to it, which is to promote the progress of science and the useful arts. And when they talked about science, they actually meant something more like literature, writings about, in general, that were useful and or meaningful, had value, had meaning. So the reference to science actually was about copyright, and useful arts, that meant the inventions that referred to patents. So it's not 180 degrees, but it's a little bit outside of modern sensibility that promoting the progress of science was about copyright, and promoting the progress of useful arts was about patent, as opposed to art, what we now think of as the arts. Now, when you evaluate a venture's financial position, you talk about tangible and intangible assets. Tangible assets, of course, are things that you can physically contact, such as buildings, vehicles, machinery, or even leases thereof, because the lease itself means that the thing itself, the tangible thing, has some you have some authority, some asset value in that object. Everything else is intangible, and the intangible assets of a company are more and more increasingly and redundantly the heart of what corporate equity, corporate value is about, and corporate valuation depends upon. For example, Microsoft is probably about 98% valued. Their stock market value is based on their copyright. Okay, and whereas other companies like Tyson's Chicken, which is a huge chicken outfit on the East Coast, they're only about 70% intangible property, but still that's 70% for an agribusiness. Now, intangible property includes know-how, includes show-how, things that your workforce can do but can't actually document or explain, but they can demonstrate and teach through demonstration. And then comes the things that are most fungible and useful in pricing and valuing when evaluating a venture, and that's intellectual property. And intellectual property has to fit into a legal definition of one of at least 5 different types, and those definitions have to be met in order for someone to say that they actually have some ownership rights in the property. Those properties can be trademark, trade dress, which is similar, of course, to trademark, of course, trade secrets, and in fact, most intellectual property is trade secrets that I'll be getting to later. Patents, which can be extremely valuable, but are also the most difficult and expensive. One moment, please. I'm giving a lecture, sweetie. And then copyright. Copyright is about the easiest to attain and is very protective of artists' rights, which means sometimes without diligence, a venture can have some valuable assets that don't quite actually have copyright to. So that's something to be very careful of, to make sure you do in fact have copyright of work that's important to your firm and that you had contracted out to have done. It's not a given that just because you paid somebody to do something as a non-employee that you have the copyright to their work. Okay. Now, almost anything that can be sensed can be a trademark, to include a scent or a sound. The Harley Davidson motorcycle rumble that you hear on their commercials, if you hear the commercials, is a sound that's trademarked. Certainly musical jingles can be trademarked, and of course words and images. I'd like to tell a quick anecdote about Dolby Labs. I had a friend, Bob McGantz, who became the head of licensing at Dolby Labs at a time when their first founding series of patents were in fact expiring. And the management all felt that they were going to lose all of their licensees because they had 140 licensees around the world who were making their own equipment using Dolby Labs technology and putting the Dolby Labs sticker on their goods. Now, it requires under patent law, if you're licensing a patent, you can't continue to license it after it expires. So what they did was they licensed the patents and also licensed underlying technology, and they also licensed the trademark altogether. And when the date of the patent expirations occurred, because it was multiple patents, the royalty rate had to go down. It had to show material decrease, and because the patents had expired. Now, Dolby Labs management, largely thought that all of those licensees would just terminate the license. But in fact, they didn't lose a single licensee. The reason being that the trademark was now what was commercially valuable. The most significant thing was the trademark, that they could still put Dolby Labs on their equipment, and the consumer would know that they were getting high quality technology when they bought the products. So the moral of the story is, don't get obsessed with only one aspect of intellectual property. They all merge together in the valuation and in the corporate equity growth of a company. Trademark. Trademarks are not established in law to help the trademark owner as much as they are meant to help the consumer know that they're buying goods from the source that they expect to be buying goods from. When they buy something that's called Coca-Cola, that it is in fact been manufactured, if not by Coke, at least under the quality control of Coca-Cola, for example. Or if you're buying a Hyundai car, you want to know that that car was made by Hyundai and isn't somebody hasn't just stuck the Hyundai imagery, logos, trademarks on the body of the vehicle. Now, when we go deeper into this, and we only have an hour, and I invite you to ask for copies of these slides. You can look at some of the background that I'm having to skip over a little bit because it's necessarily a top-level view of intellectual property we're doing tonight. You can see some of the, there's a Supreme Court reference that makes the point that the law assures a producer that it will reap the financial and reputational rewards of their trademark, but the real core ethical and legal issue and social benefit is that the consumer knows from whom they're buying the goods. Here's a quick rundown on the different types of trademarks. You can use words for word marks. You can use a name, which would be a word mark, a symbol, such as a logo, or even a device, even an object can be a trademark, such as you could argue the Jaguar, the old Jaguar that used to be on Jaguar automobiles is essentially a trademark. Now, trademarks are common law. You don't have to register with the federal government, but if you register, you get advantages in court. Your trademark is presumed to be valid. You don't have to prove to the judge or jury that your trademark is valid. It's assumed to be valid. It's the other side has to say it's not valid. And you don't have to prove that your goods were properly marked and stamped and met all the requirements. You can just file a complaint saying, here's our mark, here's what they're doing, they're infringing. A very valuable thing in a trademark dispute is if the trademark holder finds that people, members of the public actually are confused, it's actual confusion. They call you up and they say, oh, I was trying to reach, Dublin Motors. And you're not Dublin Motors, are you? So I guess I somehow got confused because you're Dublin Motor Company. That sort of thing where there's actually two entities and consumers are getting confused. That's golden for a trademark litigator to have rock solid evidence of actual confusion on the part of the public. I touched on this advantages of registration. Oh yeah, the biggest thing for a California tech company is, especially a new company, is you can maintain your application under intent to use. So you file it under intent to use and you have easily a 4-year runway before you actually have to use it in commerce to complete the registration. Let's say 3 years to keep it safe, but this allows you to reserve that name across the entire US. If you file registration, the examiner finds no competing marks, then you'll get your application allowed and you can, from the date of allowance, you have another 3 years to prove your actual use of it in interstate commerce. More advantages of federal registration. Nice thing about it is if you see somebody from offshore infringing your trademark, and I've done this, you can go to the US Customs Service after getting a court judgment, and the US Customs Service will in fact seize the goods. It's one of the few times that the police power of the state can be employed to defend a civil right, trademark. But that's only at the border, and that's for goods being imported.
So Patrick, we've got a question in chat here. It's an interesting international question. Question is, are trademarks globally protected if you have partners in various countries? And the person asking right now has a partner in British Columbia.
Yeah, there's a complicated answer. Every country has their own trademark laws. You can go through the World Intellectual Property Organization and file trademark applications through them for different countries. Countries have their own requirements. For example, when I'm filing in Canada, which I do particularly for cannabis clients, I use a Canadian law firm that I work with. So I just go ahead straight to Canada. and file there and go through their requirements. If I needed to do something like registered in the EU, I would go to Geneva at the World Intellectual Property Organization and go through their process. Basically, you're able to, generally speaking, file your application in other countries, but you're going to have to meet their needs, and you're going to have local counsel, and it's not just automatic. Now, in companies with the English law tradition, countries with the English law tradition, you do have common law rights, which you don't have in most other countries that are not based upon the English common law traditions. So what I would say is get competent legal counsel to address that, to figure out which countries you care about and figure out how to get those rights established.
Excellent.
Seem like an answer? Okay.
Excellent.
Okay. So keep interjecting, Brad, please.
Yep, will do.
On trade dress is where the product's appearance is so similar, packaging, which could be the product itself or the packaging of the product or the combination, is so similar that it will fool the public intentionally or unintentionally. It confuses the public, and the public might buy the product thinking it's made by your firm. This is a harder right to assert. I have asserted it successfully, but there is no federal registration for it, and it's much more based on common law. And I'm just cautioning you that this is a harder right to assert. Okay, so here are some examples of trade dress that have been successfully asserted. I actually asserted the appearance of a candle, this particular unique design. So don't give up on trade dress, but be aware that it's more challenging than any other IP right to assert. I have here a trademark checklist. These are the key things you want to know if you're preparing to file a trademark application. First, who's the owner? Next, is it a word mark or a design mark? If it's a design mark, attach the image to the checklist. Then the literal element means that a lot of trademarks have a logo with words in it, literal element, letters. Okay, so tease out what the literal element is. Next, I want to know, is there any international application work going on? Then probably the most important of all the question is summary of current goods and services. That's what are you intending to sell or are selling in interstate commerce under the mark. I also want to know, your attorney would want to know, is there a common law search requested? If so, has one been accomplished? Are there any results? And then what are the dates of use of your trademark in California, outside the US, and so on. So those are the key elements of information I would like, or your attorney would like to have. On trade secrets, the key thing about trade secrets is that they're all contractual. You can't establish a trade secret without someone promising that they're going to keep something confidential. And generally speaking, that should be in writing. It's very risky to do it verbally, very risky. Much harder to assert if it's a verbal promise as opposed to written. By the way, if you ever get an email out of the blue that says confidential on it, that's a shame, because there are no rights attached to such a random, unrequested communication. You don't have to honor it, but I would tell the sender that I have no duty of confidentiality here, and don't promise it if they. I mean, it's my advice, because that was rude of them to send you something and say, oh, by the way, this is confidential. But you could say to them, hey, you better be careful. That doesn't work. You can't just lay confidential documents on people and assume that you've got the right to impose trade secrets. Because, by the way, there are criminal laws applying to trade secret theft. So I would make it clear to the other party quickly that, hey, I'm not bound by a trade secret commitment here. If you're protecting your own trade secrets, you need written policies, and you need diligence. You need diligence. You can't just have a policy and then find out one day that people were posting your secrets in the lunchroom and nobody did anything about it. If that sort of thing is happening, a lack of diligence will blow your trade secret rights. different. Oh, by the way, the trade secret materials scope can be broader than you might think. Could even include pricing data, even just plans, even just ideas, because these aren't patents. These are just ideas your company is having. They can all be held under trade secret, but remember, it's got to be contractual. The agreements got to state that, and you need to put people on notice. You need to tell them this here is trade secret. I'm disclosing to you now is trade secret and is within the scope of the agreement that we signed and the understandings between us that we have memorialized in writing. So on the patent law. Yep.
We have another question here. Can you speak to the role intellectual property and copyright play in online platforms like YouTube? Where's the boundary on the copyright that individuals have and the intellectual property that has to do with how you showcase the content on the platform?
Yep. Let me get there when we let me reply to that when we get into the copyright section.
Okay.
But I have no intention of dodging the question. I just think we're about to plunge into patents, so let's stay with the order of the presentation for simplicity. Okay. Thank you, Brad. Now, you can't, there's a long history and provenance of patent laws, starting way back in Greece and Sibarius, where the winning chef of the menu of the year, menu of the festival, whoever had the recipe, not menu, whoever came up with the most delicious dish was granted the right to be the only one to cook that dish for a solid year after the festival. That's the earliest known intellectual property right that we might call a patent right. The Republic of Florence actually came out with a patent law that's pretty close to modern patent law. The architect that did the Duomo in Florence, he got several patents for machinery he used in construction of buildings. Then there's the Venetian statute. As you know, Florence and Venice were quite competitive for at least a couple centuries. So Venice came out with a patent law. Now, the thing about patent law is patents require openness. Patent means open. So the point is you disclose your secrets. You disclose your best thinking. So that's a modern idea that wasn't so appealing in other times, where it was people just kept their best work to themselves, their trade secrets to themselves, which certainly, as I said before, a lot of companies have most of their equity in their trade secrets. But generally speaking, it's good for society to encourage people to disclose their wisdom through patents. When the British Crown decided to address this concern, they came out with a statute of monopolies, which is well named because, in fact, the patent is a monopoly. It gives you the right to exclude others from practicing your invention for the term of your patent. So moving on from there, in the US right now, we have two main types of patents, although we also have plant patents. And if anyone wants to talk about cannabis patents, give me a call, but I won't spend time on that right now. There's functional versus ornamental. That's utility patents versus design patents. Utility patent, which is generally what people think of when they say patents, that's a 20-year term. And a design patent only has a 14-year term. Let's see. What is patentable? Well, it needs to fit into something that works, has to have utility. It has to be truly invented. You can't just discover it. Back in the early days of patent law in the English Crown, if you brought something new into the realm from outside the realm, that was considered patentable, or that had a possibility of being patented. But now we need it to be invented by the applicant. It must be new. And then the last quality is non-obviousness, and that actually is the big one. That's usually what the argument is about. In patent law, we like to say that only God invents with new materials, meaning that most patents are minor improvements on existing art or existing technology. So non-obviousness is usually what we're arguing about when we're negotiating with the patent office when we're trying to get a patent allowed. Particular types of subject matter are articles of manufacture, machines, composition of matter, and method. Our very first patent in the US was examined by Thomas Jefferson himself, and it had to do with extracting a type of syrup from, no, potash. It was about extracting potash, not a syrup, from trees. Potash was very important, I think, in iron smelting. And the inventor of it invented a machine and a method of using the machine that were both mentioned in the claims of the patent. So in that case, he had a method and a machine in our very first US patent. Now, composition of matter, that can be, that can be organic matter. It's not supposed to be living matter, but it can be organic matter. It can, and articles of manufacture are obvious, objects. I think are object, or I would think is would be obvious. A patent itself is defined in the three areas, structured in three components. There's the abstract, which used to be important back before, much more important back before information technology, when you could simply do keyword searches across, trillion words. But used to be very valuable and important and useful when you were doing a patent search. The specification is a description of how to make and use the invention. The specification includes the drawings. And in informality, in informal conversation, even patent attorneys will refer to the spec and the drawings, the specification on the drawings. That's not legally accurate. The legally accurate term is the specification includes text, description, and drawings. And then the claims are what you actually are claiming as property, or if it's an allowed patent, an issued patent, I mean. Then the claims are what are looked at to see exactly what the patent rights are. And the claim drafting is the primary reason you hire someone experienced at writing patent applications. Any questions, Brad?
Yeah, we got one that just came up.
Okay.
Can you speak to how patents, trade dress, and trademark work for ed tech toys like Lego Mindstorms?
Well, let's see. The shape of I'm not that familiar with that version, but for Legos in general, my familiarity there is that because there's a function to their shape, that functionality, if it's described abstractly, meaning the various features of each Lego block, in theory, if it's new and non-obvious, could describe a patentable article of manufacture. Trademark, of course, that's wherever it says Lego on it, that's the trademark. You can argue even the shape of a thing can be trademarked too. That's also true. Like the Coca-Cola bottle that is the most known, oldest version that you can conveniently grip. That was trademarked. That was the first time, I believe, was the first time a three-dimensional object was registered as a trademark. So the shape could be viewed as a trademark. The shape, the functional aspects of the shape could be patented as utility patent. The shape could also be patented as a design patent, but I'll point out, design patents are only good for 14 years, whereas a trademark can last forever if it's maintained and constant in continuous use. So that's patent, trademark. Well, trade dress would be similar in that if it has the general shape that would confuse the public into thinking they were buying a Lego product when it wasn't. In fact, when the article they were buying actually wasn't manufactured by Lego, that would be a trade dress infringement. Did I hit the points, Brad?
I believe so.
Okay.
We've got another one. You may want to take this now or later. A question about, do you need to have a patent attorney, or can you do this by yourself?
You're not legally required to have a patent attorney. There is a good book called Patent It Yourself. And I've had more than one client that had done their own patent. But I will point out they ended up coming to me for their second patent. So yes, you can do it yourself.
So I've heard the distinction from patent attorneys before between filing the provisional patent, which is pretty easy to do. And the particular example was of a high school student who filed the provisional, and then the full patent application, which is considerably more complicated.
Yes, but there's They say in some parts of the South that dog will bite you if you're not careful. A provisional patent still needs to have a full disclosure of how to make and use the invention. If there are aspects of your invention that aren't described in a provisional, then the provisional has no bearing whatsoever. In my experience, a good provisional is about 80% of the work as a non-provisional. If someone were to come to me and say, I've got a trade show in 3 days, I need to hurry up and get something filed, I would say, okay, give me drawings, let me interview you. We'll package it together as best we can and file it. Better to do that than nothing. But it would be if it came to a court case, or if it came to the examiner's desk that they had to consider the validity of the disclosure of the provisional. This would only happen if you went on to a non-provisional non-provisional process. The content needs to be there. The formatting is much looser, but the content, the actual disclosure. So I'd be when someone comes to me and says, hey, I filed a provisional, can you do a non-provisional for me? Of course I say, yes, if I understand your invention, of course. But my next question, or next thing I should say to them is, how many pages was your provisional? If somebody says to me, oh, it's 3 pages and 2 drawings, the chances that's of any value is very low, very low. You need to go into detail to describe specifically how to make and use the new and non-obvious aspects of your inventive work, not merely wave your hands and say, oh, here you use an elevator and you attach a microphone to it. I mean, you need it to be fully disclosed so somebody can go out and build one. Okay.
So here's a tricky question. Can
Sure.
research-based ideas and combinations of ideas be patented, or is it only physical things? For example, a method of working with animals and people, or a method of training students?
Educational methods have been patented. Methods can be patented. They need to be rooted in the real world, but the concept is that you can't patent an abstract idea, but most inventions are instantiations of abstract ideas. In fact, I mean, momentum in a sense is an instantiation of the idea of moving an object. You would say, okay, you place an object in motion. If you put it at the right temperature and you put it in contact with these 2 solutions, you end up with a new way to generate red colored paint, right? I mean, let's say that's patentable. Well, at the core of it, it's the idea. The idea you do these things, but the actual doing of them, the method, is patentable. Yes, I mean, given that it was a new and non-obvious way to generate red paint, to manufacture red paint. So yes, research ideas are eminently patentable. You simply need to explain in your patent application so that one of ordinary skill in the art, we call it, one of ordinary skill in the art can practice the invention, which means make it and use it, without undue experimentation. If a generally competent software engineer could take that idea, follow your flowcharts, write the software code based on the flowcharts, and have a functioning, let's call it product for lack of a better word, a functioning method, yes, the patent application would be solid to that extent. The challenge still, though, is you have to show that it does something in the real world, or you need a particularly unique computer for it, and that it's new and non-obvious.
Excellent.
Did I over answer? Did I under answer?
No, I think that's, here's an interesting one. Can I protect ideas that other people post on our app somehow?
What you would have, okay, think of the patent, the core of the patent right, or actually the patent right is established by the claim. So if you have, say, a 9-step process that's uniquely patentable by itself, and then somebody says, oh, you could also, do it at 30 degrees Celsius, but that's their idea, not yours, their idea. They introduced it, and they introduced it. You would need to include them in the patent as a co-inventor if you wanted to put that in a claim. So you're not going to be able to own any other contribution, intellectual contribution of any other party. But you could approach them and say, hey, you know, I'll cut you in on this. I would like to make you a co-inventor, and here's an agreement on how that might turn into a royalty for you.
Now, if it's posted on an app, does that put it into the public realm and therefore no longer patentable?
You have to file within 1 year of public disclosure or offer for sale, which are slightly different things. But essentially, if you have an idea and you go spreading it around, giving talks, posting videos, you know, making things publicly available, then you have a 1 year clock in the US by which time you have to file. Now, outside the US, generally that doesn't exist. I think in Europe you have 6 months, but I generally assume in the age of the internet that anything disclosed via the internet is likely to jeopardize all international rights, but you do have 1 year to file in the US. But let me answer, I think, a implied question there is that, yes, if somebody else posts this idea that you like, but you don't want to incorporate them, well, then you can't claim it. Give me a sec here. If the 1 year runs out, then you can't patent it either because it's already been out for a year. So you would be stuck in filing a patent application that either has not been disclosed and held as trade for invention that's been held as trade secret, and incorporating a new idea is unlikely to be successful under patent law.
So we've got another question here about open source software, but do you want to go through your IT-enabled invention piece before we look at that?
Let me think a moment. We'll do that under copyright. Yeah,
okay.
That's mainly a copyright question.
Okay, great.
I put some examples of claims in here. Here's an example of a composition of matter claim, just to show you that you can, in fact, patent a simple, why do I say simple, but a straightforward even description of a composition of matter. You can patent a system and method in the same patent. This is merely the well, I guess this is actually article of manufacture because you're producing a product of a reaction. Now, those are just examples of claims that you can cut your teeth on, or call me about them if you want to discuss them or other claims. An IT-enabled invention, information technology invention, information technology enabled invention, that's a particular set. There's an additional challenge to it. You need to show you've somehow, so by that I mean it's an invention, but it needs to be implemented by something that's driven by software. So you don't actually patent software. Nobody patents software. You patent a software-enabled invention. The ways to show that a software-enabled invention, an IT-enabled invention, is patentable, you have to show that one case is a particular machine. Like if you were doing some processing of chemical analysis and you had to have a carbon dioxide a monitor sensor as part of your system, well, that's not a general purpose computer. That's a particular type of machine. So that would be considered patentable, the patentable subject matter. Of course, they still need all these inventions would still need to be new and non-obvious, but that's one way that a software-enabled invention would meet the criteria of being patentable subject matter. Or transformation of matter. I love to point out, if you have a method of mixing paint and you computerize it, you made it all automated, that's fine because you're mixing a physical thing. You're taking physical material and you're transforming it in some way. So therefore, that's patentable. Otherwise, you can advance the art of information technology. I've gotten a lot of software-driven patents for inventions that had to do with improving communications efficiencies between computers and among computers. So those were general purpose computers and they were on the internet. No matter per se was being transformed other than the electrical state of memory cells, because different different machine level code was being programmed into them, and data was being stored in memory, which requires, of course, the energizing or de-energizing the memory cells. But the point is, it advanced the art. It made information technology networks more efficient in the cases that it was addressing. So that's one way also to get around, get into a patentable subject matter area, which is what you want for an information technology enabled invention. Lastly is narrowing the claim scope. So you're not just saying, you know, I've got a way of making, of a new way of generating emails. But if you can show that this new way of generating emails causes this particular problem to be solved, then you can get you're more likely to get a patent for that particular implementation of your email invention, as opposed to making it applicable to all emails or all email generation. It's kind of a complicated subject, but I just wanted to give you a taste for that. That don't give up if you have a software-enabled invention, but do understand that it will need to be, the application will need to be drafted more vigorously with greater diligence than if it's a mechanical patent application. Let's see, what's our time? Oh my gosh. Okay, so I'm gonna move fast. Duty of candor on patents, you need to disclose what you're aware of the prior art to help the examiner understand how novel and non-obvious your invention is. You're not required to do any patent searching or any prior art searching, but if you do that searching, you need to disclose it to the examiner. And for sure, if you're on a team of people, make sure that there's one person who's keeping track of any prior art knowledge that anyone on the team has, because knowledge by anyone involved in the patent process is imputed to everyone else. So you need to know what everyone knows if they're doing any patent searching, or what are they already coming in the door, what they know about the prior art. And you need to name the true inventors. You can't add somebody to give them a gift of recognition, and you can't and also you can't not mention someone because they're an annoying person and a problem for some reason, and you can't add like what has happened occasionally happens. An engineering manager decides that he or she should be named as an inventor on every patent application coming out of the department, which is only valid if that person significantly contributed inventive matter to the patent application. This is an invention disclosure form. We're running out of time, but I wanted to give you an idea that there is a way to organize your thoughts so that when you go to meet with a patent attorney, you can have a more effective and efficient conversation, which would be good for everyone. For international filings, I'll leave you with this chart. Basic ideas: if you file in the U.S., file within 12 months with Geneva under the Patent Cooperation Treaty. That's through the World Intellectual Property Organization. I mean, you can file this through the U.S., but the World Intellectual Property Organization is the parent organization that monitors Patent Cooperation Treaty applications. So the key things are: file within 12 months the Patent Cooperation Treaty application, within 12 months of filing the US application. And then you have till the 30th month to file it, mostly in other countries. I think Europe gives you an extra month, but don't rely on that, because your patent attorney is going to need time to organize foreign filings for you. So I would say at like the 2-year mark after the US filing, start getting your strategy together and lining up your patent drafting talent so that you can get foreign filings done properly and on time. EU industrial design right, that's like a US design patent. I don't have time to go deeper into that, but just keep in mind, I'll leave you with this, that Europe also recognizes ornamental designs as being subject to intellectual property rights. And that's valuable if you're a small company and you want to show investors that you're thinking ahead of time, and you're laying out your IP strategy outside the US. Also, they're fairly inexpensive to get, and they're fairly quick to secure compared to a utility patent. Copyright. Okay, there's a little history starting with the Statute of Queen Anne. Happy to discuss this with any of you at any time. Subject matter, original works of authorship. It has to be about the fixation of the expression. It's not about the idea itself. Like if you write up a new way of breeding tomatoes, crossbreeding tomatoes, that writing is subject to copyright, but you don't necessarily have any patent rights to the practice of the idea. People just, it's a simple matter that no one is allowed to merely copy your instructions and pass them around. That's copyright infringement. Would they be allowed to read your instructions and practice them, or read your instructions and rewrite them in a way that has the same substance as your writing? Yes, but they wouldn't have a right to simply copy your writing. All kinds of things are covered by copyright, to include choreography and pantomimes and sound recordings and even architectural works. I now believe that ship architectures are included in that. There was a gap in copyright for a long time. Just basically anything that can be created that can be affixed down in some fixed form, it's probably subject to copyright. Now you do get copyright as a natural right. You do get copyright as a natural right, but you want to file, you want to register it in order to get significant advantages if you have to assert those rights. If I get a letter, if my client or I get a letter on behalf of my client that says we're infringing copyright, that letter has a lot more power to it if it references a copyright registration, because that means the other side can get attorney's fees and they can get statutory judgments of $175,000. Meaning if the judge doesn't like my client, doesn't like me, doesn't like what happened, they can say, okay, you're gonna pay your opponent's legal fees and 175K just coming out the gate. So register, register, register. Copyright's complicated. I love Mark Twain's comments about that, or comment about that. Be aware, copyright gets complicated very quickly. I know people who have done world famous work that didn't get copyrighted properly. It's, even though copyright generally is very good to creators, be aware there are twists and turns in the law. So if something's important to you, I would take the time to go check out the legal landscape with someone who's familiar with copyright law. It copyright's about the idea, the expression of an idea, not the underlying idea itself. We refer to the creator of the work as the author, even if that work is musical or a movement such as choreography, we still refer to them as the author. So if you, and I want to point out that if you're using the work of someone else, even if you paid for it, you don't necessarily have copyright. You've paid for the right to use it, meaning we would call that a non-exclusive license to use it. But they might still have the right to use it themselves or to license it to others. Here's why you should register. I'll leave that slide for you because we are tight on time. You want to, ideally, you're going to file within 3 months of publication, and you definitely want to file before the first infringement. You have a 3-month grace period. So in the first 3 months, if someone infringes your work, you're covered. But if if you wait more than 3 months to file and to file for registration, and if they infringe before you file, if you filed after the 3rd month, then you don't get all these advantages. So bottom line, file early and often. If you've got a very important website, I would literally file it every 3 months, like clockwork is part of the things you do. Yeah. Copyright lasts a long time, 70 years after the death of the author, or 95 years from publication, or 120 years from creation, whichever is shorter. Works aren't always published. Publication is a very specific term here. So just bear it in mind. And something can be created, but then not published. So they have to have the 2 cases where 120 years from creation, because maybe it isn't published for 40 years, okay? And they don't want you to to sit on publication in order to extend your copyright. So they do have a limit on works, no matter when they're published, to 120 years from creation. If you want to assert infringement successfully, you're going to have to show the person that you have the valid copyright. And if someone did work for you and they're not an employee, that work probably needs to be assigned in writing, a written signature. The law is very clear about that. The purpose of it is to ensure that artists don't get ripped off. The creators knowingly assign their copyright to you, okay? Copyright there's a number of rights. The biggest, of course, is the right to reproduce the work, but it's also derivative work. That's why you can't just tweak something a little and say, well, I'm not, I wrote a book that only slightly alters, but slightly alters the book that I was inspired by. Well, that's a derivative work, most likely, and that is subject to copyright. These are cases where you don't have a copyright. Biggest example of this, I would say, is the movie industry, where there are so many contributors, so much creative work is going on. It's understood that all the contributors to a motion picture, even if they're contractors, would know that they are donating their creative work to the collaborative work of the film. Yeah. All kinds of works can be protected. I think this might be a redundant slide, actually, but there you have it. What's not protectable? This is good to know. Titles of books aren't protectable. It has to be a book series, like Idiot's Guide to or Dummy's Guide to. Those titles are copyrightable because they're series. They're series of works, and not just one work. Okay. And of course, the information on a phone book can't be copyrighted because that's merely a listing of information. And that was the big argument about software code. Is software code instrumental or is it an expression? And we're still working that out. In fact, right now there's a huge lawsuit between Oracle and Google about whether or not APIs are expressions or actually useful tools, which therefore wouldn't be subject to copyright. Here's our key things you want to know if you're going to file for a copyright registration. Who's the applicant? Is it literary work? Is it a 2D visual? Those are what I have down there because those are the most common. Has it been filed in any other country? And then who's the author and have they assigned it? That's all on the checklist, which we only see page 1 of here. Contact me or contact the Startup Launchpad, and they'll be happy to send you a full copy of this checklist. All right, that's the end of my presentation, and let's go to that question then. Brad, could you repeat the question for me?
Yeah, so can you speak to the role intellectual property and copyright play in online platforms like YouTube?
Right, so the big egregious but legal process is YouTube says, if you're going to post here, you give us a right to own a copy of your work. And that's that. That's the end of it. I believe the latest license I saw says you have the right to tell them to take it down, but they insist they still have the right to keep a copy. But the problem is you've now extended copyright to them, and that's not a good thing. It's better to own your own copyright in its entirety. What I want to really say here is it's all contractual. If you had videotaped something and you wanted to post it online and you go to a third party, let's say vendor, for lack of a better word, they have a contract, they have an agreement. They're going to say, we'll post this, and in return, you will, A, B, or C, or A, B, and C. That's what you need to be careful of. What are their effectively terms of service in such a transaction? And those terms of service change. And there ought to be law prohibiting the egregious, the overreach of these big tech companies in taking ownership of some aspect of the copyright of what's contributed to their website. So I guess I got to say the devil's in the details. What exactly did you agree to when you posted it, when you posted your material?
So we've got another here. Can you speak to how open source software and hardware licenses are different from proprietary software and hardware? And how do you think about hybrid models where the key elements of hardware, for example, a PCBA is open source, and yet the final product is patented, trademarked, and trade dressed?
Well, these terms are all dangerous because open source merely means you can see valuable information. That's a bit of a stretch, but it's essentially with the point here. Some information that is of value, but it doesn't say you can use it. It just says, hey, here it is. Here's my source code. Hey, here's my schematics. Here's how you could do it. It doesn't, open source per se doesn't state you can go ahead and take my code and alter it and use it in any way you want to. It doesn't say, it doesn't immediately imply you can take this information I'm presenting in an open way and use it without my permission. For example, one of the permissions is attribution. Sometimes people will say, you can use my software code if it's for nonprofit or if it's for personal use only, but you need to attribute it to me. You need to have it down there. Copyright by Brad Barbeau of Monterey Bay, right? So open source agreements or the licenses need to be read carefully to see what they say. And there's dozens of flavors of them out there. You tread lightly, tread very lightly. Make sure what agreement they have and read it thoroughly. And you probably need it looked at by somebody who's very familiar with the ins and outs of these open source agreements.
All right.
It's not a great answer, but the answer is it's a complicated world in copyright, and don't make assumptions about fair use. That's very, very dangerous. In copyright, do not ask for forgiveness rather than permission. Ask for permission. You want to ask for permission.
So a question from Richard de Andrade: if party A owns a patent on a plant and licenses exclusive use to party B, and party B licenses exclusively to party C, however, party B does not officially assign the rights by notifying party A, does party C have a claim on the rights assigned to party B by party A?
If the agreements are written that way, if the agreement between A and B state that B has no duty to report, then yeah. But there would be a sloppy agreement. That would be party A having a bad attorney who didn't specify that, here's an exclusive license, but you have a duty of accounting, we call it, which means accounting means description of what's happening as well as payment for what's happening, payment of the royalties, and the disclosure of the income received from the licensing. So that situation is conceivable, but it would have required one very incompetent attorney at the beginning of that chain of elements.
Quick question for a follow-up, just 2 seconds, Patrick. It's Richard. If party B has the duty of accounting to party A, but didn't do the reporting, in other words, the additional license between B and C was due to be reported to A by B, but that wasn't done.
Well, generally speaking, there would be damages because the reporting wasn't done, which would imply the payments weren't done either, right? Mm-hmm. So I can't quite say there'd be an infringement yet. It would all depend upon the particulars. What did the agreement say?
Okay.
And of how poorly was party A's contract drafted.
Okay. Thank you.
Great.
Well, Mark Twain said it.
Right. And Amitesh asks, can a combination of two known materials, such as herbal products in a particular quantity, be patented?
If the combination is new, if it produces an unexpected benefit, which I would call non-obvious, a non-obvious result. Yes, yes, absolutely.
So it can't simply be that you've got a different combination of the ingredients than anybody else does. There's got to be some impact of that new combination.
Well, I gotta be careful there because it's true. So you can patent something that gives you the same result, but does it by different elements.
Okay.
So it's a little bit broader than that, but essentially it's got to have an effect that's meaningful, and it has to do it in a way that's not obvious.
Okay. All right, that's the end. I think I covered all of the questions that were in chat. If there, and give everybody a last chance to put in your questions if you've got them. Otherwise, I want to thank you very much, Patrick, for your time and your expertise, and encourage people to reach out to patrick.reilly@ipsociety.net. His phone number is there. You can also reach Patrick through us. You startupmb@startupmontereybay.com. Thank you, everybody, for attending, and we'll let you know when we do future seminars like this, which we will be doing. Have a good night, everybody.
Thank you, Brad. Thank you for everyone attending.